Welcome to the Foundry, where leaders are forged daily. And now your host, George Roberts.
Welcome back, entrepreneurs. Today, we have the pleasure of discussing how to raise capital legally with securities attorney Nick Moore. Welcome to the show, Nick.
Hey, George. Thanks for having me on.
Well, I'm excited to do this. It's been a long time that I've wanted to have a securities attorney because I know there are a lot of questions that syndicators and aspiring syndicators have about securities. So before we get into that, let's get down to business by telling the audience briefly about your background and your law firm's practice.
Absolutely. So, Nick Moore, partner at Robinson Franzman. We focus in multifamily, doing the real estate transactions and the syndication paperwork. Okay, so we're full service, vertically integrated, handle everything from soup to nuts. We do hundreds of millions of dollars in transactional volume per year. Total between us is easily over $1 billion lifetime. My practice specifically is nationally, because as you know, I am in Atlanta, Georgia. And George, I think are you in the Midwest? Where are you?
I'm in the Midwest, but I invest not too far away from you. So I'm also in Central Florida and East Tennessee.
Yeah, I remember you telling me about that. That's terrific. So I have a national practice, and I've tried to be as engaging and ever present as I can be on LinkedIn, and that's really helped me expand my footprint well beyond Atlanta. And while I do have a few local clients, my practice is comprised predominantly of residents of other states, and so I'm able to practice law from a transactional perspective in other states, being licensed here in Georgia. And then I can facilitate the securities offering document drafting for you, as that is federal law, and can issue those in all 50 states as well. Was elected twice as a Georgia super lawyer in the last 2 consecutive years. Not too many accolades in law for us. And so that's a peer voted process and election there, or selection rather. Reserved for top 2.5% of the vote getters. Well received with my peers, which means a lot, but mostly the most important opinion, of course, is yours and those of my clients. And so as I continue to build my practice, I continue to refine and try to become more efficient on your behalf. And so that is my brand and my mission.
That's great. And today, my agenda is basically to make sure that everybody in the audience that's interested in becoming a syndicator has a firm foundation so that you can move forward with confidence. But I also want to make sure that our audience understands all the excitement and drama of securities law, and hopefully how to avoid becoming the centerpiece of that drama.
Yeah, you want to be in the news for good things, not bad. And you want to, if you're running a 506c offering and you're advertising, that's your public facing security stuff. And not breaching Rule 10b-5 of the Act, of the Securities Act of 33, which is fraud, of course, and intentional misrepresentation. Avoid that, you should be fine, but also make sure that you're qualifying for the exemptions appropriately, which of course is the advice that I give on a daily basis. And you and I talked before, a brief disclaimer. What we're talking about today, of course, is academic and hypothetical. If you need real actionable advice on your personal facts, please do reach out. But don't rely on the things that I'm saying, outside of being able to communicate with me that under an engagement letter, which will benefit all of us. But definitely excited to talk about my experience and just educate.
Yeah, I love that. I'm thinking maybe I should add one of those snappy disclaimers to all of my shows.
Just the lawyers. Just the lawyers. You can,
okay.
Yeah, I mean, what you're doing is fantastic. I have to do that because someone somewhere was like, well, I heard this podcast. And so you just kind of do those disclaimers just to.
Absolutely.
Yeah.
Well, okay. So let's cue the dramatic music. So I own an apartment in Florida, which is just southeast of a place known as Howie in the Hills, where one of the most celebrated securities law cases transpired. So can you give us a brief rundown of the events that unfolded as one of the great citrus growers of all time, William John Howie, adopted a new business model that attracted the unwanted attention of the Securities and Exchange Commission?
Yeah, so ultimately, to distill it down to its component part, a security is in effect a profit earned by another's effort. And so where capital is contributed without participation in the operation of the affairs, the Securities and Exchange Commission has determined that that is a security. And so all securities actually have to be registered, okay? Meaning the SEC needs to know and to some extent have reviewed all the information surrounding the investment that has created this security that we're speaking of. And so obviously the Securities Act of 33 being on the heels of the Great Depression and all of the implications of that and just the free for all that was the private equity industry, they revamped, and that's why they required registration. Now, in the formulation of that law, they also recognized that it could be a restraint on trade, okay, and that we could provide for very limited exceptions. And so now, when you have a security, just as you described and through that sort of landmark case, there's steps that you can take to avoid and be exempt from registration, and then you can continue to raise capital without having to send all of your items to be pre-vetted by the SEC.
Great. And I love that history too, because later on, I want to get into how, the 1933 Securities Act and how we built on that. And you have a lot of new ways of doing things that really weren't available at the time that those sort of laws initially came on the scene.
Right.
So do you want to run through the 4-prong Howie test and how people will know whether they're selling a security or how they might be selling a security and that they should engage a legal professional?
What we want to distill it down to so that the audience generally, when they're contemplating doing the offering investment into the company, is to think,
are you ready to build passive income through investing in multifamily real estate? Take the next step by heading to www.horizonmultifamily.com and click Get Started to schedule a call.
Are you really and truly, and the Howie test is really an investment contract, okay? And so here, really the question that you're asking yourself and asking, about your company is, do you wish to have your investors participate? Or do you wish to endeavor all of the undertakings for the company exclusively or with a small team, right? And if the answer really to the latter is yes, then you're likely issuing a security to your investors. Okay, you can certainly do a joint venture, as many of the listeners are probably familiar with, and that's where me, George, and 2 of our friends get together and we want to go take down an apartment complex, and we're just going to kind of quarterback by committee. We're all going to have responsibilities with the company and things, and ultimately we'll put the at-risk capital up between the 4 of us, and and then enjoy and distribute the profits accordingly. Now, naturally, as deals get bigger and bigger, and multifamily deals can even reach $100 million or more, you need to find probably capital outside of your core group. And so if you are going to do that without the capital that you're raising from those investors participating in the operation, and the asset management and other things, underwritings, just daily responsibilities, then you have created a security. And with that, that's immediate. Really, the best part of the question that you asked, George, is really when to consult a securities professional. And I think unless you know 100% that it's just you undertaking the property by yourself, and you're of course buying it, and you're coming up with the bridge capital between your loan and the purchase price, talk to an attorney about what your design is. I've spoken in front of many groups. I've done many podcasts and been posed many a hypothetical for which the asker of the question didn't know the answer or thought that they did and was actually incorrect. And so having a securities professional as a sounding board, and also, having somebody that you can access to say, hey, here's what we're contemplating. What do you think? And again, where you have an engagement letter and you are represented, you can rely on that advice. And find a knowledgeable attorney who's familiar with your facts. If it's the first time they've heard it, it's probably not the best attorney for that particular situation. And it's okay to keep your second cousin as your attorney, and then perhaps go seek a professional who is, well versed in the subject matter of securities, and just let them handle that part. And then, you can go back to Tom or Cindy and on your other general matters. But allow somebody like myself to be able to unpack that for you. Well, what do you expect these partners to do, and where do you expect to get this capital? And then if you get that capital and someone perceives that as a security, are you going to register, or are you going to try to qualify for an exemption? And of course, the best answer is the latter, is to qualify for that exemption. And so you want to know that off the bat, because that's also going to help you communicate with your lender and set expectations there. And they're your biggest investor, right? Because they're 80% LTC or thereabouts. And so they want to know what you're doing, and you want to know how to communicate that. So early on, ask yourself, are my silent partners, or are my partners going to be silent or not? And if the answer is yes, it's a security.
Right. So I hear at least four things that I really want to call out there. And the first is that it's better to consult. And one of the things I've noticed about securities attorneys now, I know you and I, we've never done a deal together, but I've called you up and we've had some conversations, is that they tend to be very open, right? They're very engaging. They're looking to network and meet people. And if you call up and you say, hey, I'm looking to do this sort of a deal, is this something that I would need to retain your services for? That's something that they would be very open to discussing, I believe.
Absolutely. No, and you're covering those bases, going forward with the confidence, having that communication. And look, I'll be honest with you. I'm happy to take calls and respond to things in certain situations with a small set of facts without billing for it. Ultimately, if the design necessitates the offering documents that we'll need for the exemption, at that time, my clients have overwhelmingly considered my services and moved forward. I've had very few people ask enough questions to unequivocally establish a syndication and then not move forward with my services. And I think it's just so wise that, and it's not even me, right? It's the fact that they're seeking that counsel, and then they're paying compensation for that counsel and relying on it, and then ultimately protecting their investment, their own investment, as well as those of their investors by being scrupulous. And yes, there's an expense on the front end when you get there, but it's so well worth it. So well worth it.
Yeah, absolutely. I mean, just to state the obvious, listening to this podcast does not establish an attorney-client relationship. So
no, it doesn't. I wish it did, because then I'd just send everybody wire instructions.
Send them a bill.
But exactly. But I'll get to know you before I send you a bill. I'm a nice guy.
That's great. I'll give you the registration list, and you can send that out. So the other things I wanted to call out is, you mentioned what I would call a sort of a safe situation. I would call it a joint venture, where you said you got three partners and we're all working. We're all putting in sweat. We're not relying, for example, on the efforts of another.
Correct.
Yeah. And then another thing. Yep. Oh, go ahead.
Nope, that was it. Just confirming.
Is that I'm hearing a common enterprise, right? If you're sharing in the upside, that's essentially a common enterprise. And that's one of the things you have to look out for in terms of investment contracts.
That's right.
Yeah. And so then this is where I would like to go into the scenarios, if you don't mind.
Okay.
So let's say scenario number one, I'll call this the flip house scenario. I'm flipping a home. I'll be borrowing the money at a rate of 12%, using the home as collateral, and the loan is due in 6 months. Does that sound like something that would ordinarily require a securities attorney to do?
Who's your lender?
Oh, okay. So it'll be a private individual, and they're working out of an LLC.
All right. How often do they provide loans for this particular type of venture?
Oh, this is something they do regularly.
Yes, you need to consult your securities professional, because they could be issuing debt securities. Okay.
Oh,
so it's not all equity. There are debt securities out there. much of the time they'll have to issue a PPM or some other things. There's some small securities implications there on their side. For yours, not necessarily. Okay. When they go do their private funding, you want to know, well, there's not really the security between you as the borrower and them as the lender, but depending on where they're getting their capital, that the lender could have the securities implication. I should have clarified that. That lender has some securities implications. But if it is a true loan secured by a promissory note and collateral, then generally that's acceptable. But then we would still look to unpack the LLC on our side, right? That is borrowing those funds and what comprises our entity, okay, to determine if there's an exemption that we need to qualify for. In your facts, if in this fix and flip, we're a single member LLC and we're just using that LLC to limit our liability and for real no other purpose, maybe some tax advantages, then no, that would not be perceived as a security.
Great. And I love the point that you bring up. It's not just about you not doing something that violates the law, but if you're doing business with somebody who violates the law, that's a great way to see the deal go sour. And you might want to ask a few additional questions.
No, that's exactly right. And you do want to ask your private lenders, what's the expectation here? It's one thing to just get a promissory note. It's another thing just to ensure that you're not getting caught up, because here's the real implication. Once the funds are loaned, they've provided it to you, right? And then really the terms of the contract come into play. But if for some reason, heaven forbid, that private lender were not to have been exempt from what would be determined to be a debt security, you could conceivably get caught up in having to explain certain situations, and that may actually have to result in you obtaining representation, and that ain't free. And so do you want to incur the expense of representation in an endeavor that you feel you didn't do anything wrong? And I think the overwhelming answer to that is no. So just be scrupulous about those private lenders, because they may be subject to securities laws. So yeah, absolutely.
Great. And I love where you went with that with the debt security, because of course, one of the prongs of that Howie test is from a common enterprise. And if you're on different sides of the table, like a lender, right, that doesn't necessarily mean that just because you're not on the same side of the table that you don't have a type of security, a debt security, that is to say. And a lot of people will say like, hey, I mean, this is just debt. I mean, but you're right. If it's, and that was actually the next question I want to ask you is, what if you're getting it from your friends or your family or acquaintances and they don't ordinarily lend? That is one of the ways that you can potentially get into trouble. Or they
conceivably, right? Look, what we're talking about here, it's important to note that it's all a facts and circumstances determination by the SEC. And they are the judge, jury, and executioner regarding that. And so you can introduce mitigating factors and things, and they're not out here with an agenda necessarily, to the extent you offer mitigating evidence, or you can rebut the presumption that it's a security or something. But ultimately, the reason I was asking whether that particular lender, not to necessarily go down that rabbit hole, but just to extrapolate a little bit on this, if this private lender were just to issue this, maybe once or twice, and it really depends on where they're obtaining their funds. If they're obtaining these funds and then putting them through almost like a fund model, well, then of course. But also if they're just doing, sort of some private lending, it just could be considered a debt security and something to explore. But usually, once or twice, or just a random promissory note to help bridge capital or do a construction loan or CapEx or something like that is not a security and can just be a normal loan, has to comport with the usury laws, of course, and the interest rate has to be reasonable. But outside of that, you wouldn't have to register. And then, of course, your lender might not either. But you would want to have sort of, where there's a concern, I think you would be best to have an opinion of counsel from that lender or something else in writing that says, hey, we're good here, and then you can proceed.
Right. And then maybe another distinction to draw is between consumer credit versus sort of an investor loan.
Well, yeah, no, that's exactly right. And the investor loan is the one where there's going to be much more of a possible securities implication versus consumer credit, which of course they are extending as a company. Well, here's the interesting thing. You can also have consumer credit where that particular credit facility is complying, or they register their security.
Right.
Okay.
Right.
These larger institutions will register securities where the investment funds are the ones being used to lend. Okay. And those are the first also to be investigated by the SEC, because last I understood, the SEC enforcement division has a bonus compensation based on their wins, if you will. And so versus coming after, Tom, who loaned $250,000 on a construction loan, for their pal down the street, right? This huge credit facility of $410 million, and they didn't register when they were taking the income, the investments, and then passing those along in exchange for the interest, and then passing that interest along. The latter is a huge concern and risk. And I've seen a number of big dominoes fall who didn't comport with registrations. And the worst part is they had all the resources to be able to comport and either register their security or be exempt. And so shame on them anyway.
Exactly. And then here's some other myths that I'd sort of like to dispel. So if it's a small deal, some people say like, oh yeah, you don't have to register that.
No, that's right. I was funny. I was speaking at a Michael Blunt boot camp a couple weeks ago, and very, very intelligent contributor, not contributor, but boot camper, smart guy, knows his stuff. But he made a good point, because I posed a hypothetical, just as you mentioned, where there's like, it's your buddy, it's only one investor, he's giving you 200K, he doesn't even have the time to participate, yada yada. And part of his response, when I posed, whether it was a joint venture or syndication, he goes, well, isn't an exemption. You don't get a hall pass for, it's just my buddy, now there is a limited exemption for immediate family. And just explore that a little bit further. But typically people aren't just borrowing just from immediate family, like parents and other things. Just be scrupulous, always try to qualify for the exemption where you can. Don't rest on any sort of your loophole or anything like that, because you could give yourself just enough rope to, unfortunately, hang yourself. So
all right, great. So let's call the next scenario the club deal. So I'm buying a fourplex using capital pooled from two investors and myself. The other two investors are completely passive. I think you sort of got into that just a moment ago, right?
Yep, didn't mean to preempt your question, but
no,
yeah, so that would be a securities implication, and that would require an exemption or registration. Again, now here's how you can avoid it. Go to those two and say, look, we can avoid paying Nick Moore for the offering docs if we joint venture and you guys actually participate. Why don't you use your capital? We'll get in here. You'll get your hands dirty doing this work. We'll do the property management ourselves on the fourplex. We'll go, open the accounts together. We'll be authorized signers. We'll work with the lender. We'll sign on the loan together, all that. And then you're a joint venture, and then you avoided the cost of the securities, exemption. But on your basic facts there, if they are persistent about or insistent on being passive, then yes, absolutely, despite the number or volume, all that's a security and needs to be registered or exempt.
Yeah, awesome. And of course, that tends to limit the size of the deal. I think that you can't have more than a certain number of signers. Most banks won't accept more than a certain number. I want to say like more than 5 seems to be pretty common. But hey, if you can do it like that, I've done joint ventures. I think joint ventures are wonderful.
They're
and
great.
I think, yeah, syndication is not necessarily where it's at. It's a great place to be, but it's not the only way to go. All right.
Exactly right.
How about this? Scenario number 4. So I'm syndicating an apartment and I've applied for the appropriate exemption through my fully qualified securities attorney. But I don't tell my attorney that I'm compensating my partners partly on the amount of capital raised.
All right. So this is academic. Okay. Now, and the biggest consideration for me, and I've got a background in litigation, so I'm going to, kind of put that hat on. It really, what can help, and again, it's a facts and circumstances determination, but I would be interested to know how soon those partners were involved in the deal. Now, if they had formed a partnership well in advance of going and trying to obtain, identify, or undertake an asset, then you could have your own internal compensation be predicated on whatever, because you're truly principals of that partnership. And so however you're defining that is fine, as long as you're operational, as long as you are an integrated and participating, a partner of that company. Remember, the biggest issue is the brokerage of investment, which is linking the issuer with the investor for compensation. And in this case, if we at the outset contemplated that we are running this as a partnership, and that we're just going to do our own internal compensation based on who brings the capital to the table, that's not brokerage, because you are the principal of the company. Okay. Now, I don't know of any other facts based on what you provided that would make me think that there's a concern of any brokerage. There would certainly be if those partners who are getting compensated for bringing capital didn't do anything with the company and pretty much just connected the capital, then that could be perceived as brokerage. But where you're fully active and you're bringing that capital in, it's not brokerage. It's investment into your product of which you're the principal.
Good. I love those nuances because I think they're very important. And hopefully this is causing people to become more likely to want to consult rather than less. And the reason I like to know about the law, I'm really fascinated by the law, is because I feel like your attorney can't answer the question you don't ask. So if you don't realize, you might
can't bill you for it either.
I can't bill you for it either. Two sides to that.
So ask and ye shall receive the bill. No, I'm kidding. But let's be honest, ask the questions and find an attorney who's not going to nickel and dime you. And I don't do that. There's, of course, costs associated with the offering docs, which is generally flat fee. The property stuff and transactional stuff is billed by the hour because that's market. You can come up with flat fees with more trusted clients that have proof of close, but find a good attorney who's responsive and can answer these questions, and that 2 days later you don't have a bill, or who at least has the transparency up front to say, hey, in these situations where I really feel like I'm giving you actionable advice, let's bill against the retainer on that. We'll take a few dollars up front and just level set expectation there.
Yeah, I think that's totally fair. And I feel like a lot of attorneys in this business, they really go off of the one large fee model. In other words, they give you a little advice up front. And then when you get that deal and you come to them, then the bill, I know it ranges. Would you be willing to give us a sort of a range that you might see in this business to put together a syndication?
Yeah, absolutely. So I'll give you a couple of different scenarios. If it's just a JV and we're doing property, right? Because joint venture, we don't have securities documents. I generally work around the $3,500 mark. And the reason being is we're doing purchase and sale. I'll do some lender due diligence and we'll get some operating agreements and things created. And if there's some heavier lifting, I'll talk to you about that at the outset, and or when we recognize there's a higher volume and perhaps the fees adjusted from there, but only reasonably, right? And only to the extent that I've talked to my client about it. The second scenario is a syndication of a smaller deal, right? And so we're probably doing a bank loan. Maybe if you're doing a Freddie Mac small balance loan, which can go up to $7 million, it's actually a slightly higher fee because of all the requirements that the Freddie Mac deals require. And so those are generally around $10,000 flat fee, but will also come with most of the time we'll put the offering docs and stuff in there. Again, it just depends on the specific situation, but those run about $10,000. If you have just a small bank loan and you're doing a smaller syndication, I've charged anywhere from $8,000 to $10,000 for those. And then anything really in the sort of the 8, 9, 10 million and up, it's not going to be a bank loan. It's not going to be a Freddie Mac small balance, and we're doing Fannie Mae, or we're doing bridge loan, or I guess conceivably a large bank loan, while those are somewhat rare at that size. I do an upfront retainer for the first 2 deals generally. Okay. And the reason, and it's $10,000 initial retainer, that's really the cost of the offering documents for your syndication in that context. And then we bill all the real estate work by the hour, but that's not paid until closing. That way you can do your raise. We have some understanding as we go through the process and transparency as to where the bill is and where it's going. And then generally with my higher performing clients and those who have what we call proof of close, we'll just parlay the entire fee at the end. Okay, so I'll put the $10,000 offering docs in there, which, by the way, is about $2,500 under market generally. And if it's a volume play, I can even do better than that. But for those higher performing clients, I'll just put just parlay the whole thing to closing. And it's nice because when you get enough of those and you stack them up, you get those huge wins during the month. And that can really, it's been terrific for me because it's anchored my practice. And then you'll just get a nice 20, 30, 40, $50,000 hit in a month, plus all the other stuff that you're doing. And it was great for your client because now they can spend that money on good faith deposits, third-party reports that they may have to pay for up front, earnest money deposits, and other things, of course, that we know are germane to taking down the asset. So just try to stay nimble and go on a case by case. But those are relative. That's my ballpark.
Makes sense. And then that really determines in large part what can be syndicated. And that's what I've heard. Essentially, you're not going to spend less than $10,000. So you're not going to syndicate a $200,000 home. If that's how you decided that you want to structure the deal, you just have to, I would say, not do that deal.
Well, that's right. Or at least, yeah, it's funny, man. I think generally I agree. But I don't want somebody to forego an opportunity without first talking to me about what they're contemplating and things like that to see if there's if it means me taking a fee haircut. Obviously I get all the haircuts you get. Then I'm happy to have that conversation. And if it's something that's the difference between you taking down something that's going to be good for you and feed your family, I'm all about that. I'm not all about the big sophisticated operators that want to come in and pay me nothing. Like I don't have time for that. I say no all the time, or I'd give them kind of a take it or leave it fee. But if in this case, George, you came to me and you wanted to do a flip or something, and you're like, hey, I'm going to use some capital. I want to do it the right way in a securities thing. I can knock that fee down and make it happen for you. Within reason, of course. I can't work for free because, man, daycare. Whew. But I'm happy to work with you and make sure you can continue to grow and pursue your strategy.
Yeah, and this is obviously very complicated. I wanted to ask you at one point, why are these private placement memoranda 100 pages or more?
Well, so they have to be, right? I venture to say the first one was a page, and then something happened, and then something else happened, and then a bunch of things happened. And so I think it's important for the audience to know that the PPM is really just a disclaimer and disclosure document. That's all it is. It's not a contract. It summarizes a contract because it summarizes the operating agreement. It has a subscription agreement attached to it because you're subscribing to the investment in those units, right? And then you're signing on to the operating agreement as that class whatever member, okay? But the PPM is there as a CYA, okay, for the operator. And it's an acknowledgement document so that when you take those exhibits, you're taking them subject to the fact that you've read this, you've looked at the risk factors, you've looked at the conflict of interest, and by virtue of signing and subscribing, you waive really any right to come back and be like, well, I didn't know that. I didn't know he was going to do that, right? And so it's important to distinguish at that point between your sophisticated and non-accredited investors, right? And then your accredited. The accredited have the threshold they have, $200,000 in the preceding 2 years with a reasonable expectation you're going to earn that in the current year, or $1 million net worth. And then there's a couple other small qualifiers. But the SEC has determined that you have the liquidity and capacity and ability to go get sophisticated counsel to pass on the merits of that offering on your behalf. And so that's why the disclosure actually reduced for accredited investors, because they should be sophisticated enough being accredited that they can determine their appetite for the risk, okay, that's there. Now in a 506B, when they're sophisticated but not accredited, you have many more disclosures you have to make, pro formas and financials that you have to deliver, and otherwise talk about the merits of the offering, such that as they're sophisticated in reviewing these things, they understand the implications. They understand, or at least they disclaim that they understand, right? Or they're representing that they understand. And so they can't come back if the deal goes south and get their money back. You don't get the benefit of the upside of the deal and then get to walk when you incur and absorb the risk. And that's in effect the purpose of the PPM document.
I love it. And I get a lot of investors say, I can't stand reading this 100 pages. maybe describing it mainly as sort of a disclosure document, and consider that really, look at that operating agreement. This is what we're essentially bound by. This is more or less.
That's bingo. Here's a good analogy. The PPM is the flyer. The operating agreement is the fine print. Okay. You can talk about all the stuff that's on the flyer, but if you go bring up an issue, they're going to be like, but read at the bottom, read the fine print. It says, there's an asterisk there, means this, and that, and then they're covered because of what's in the fine print. So read all of the documents. The good news is look, there is a learning curve to reading these things. Some people don't read them as scrupulously once they get more familiar with them. Like, there's certain risk factors that are just germane to multifamily, and you read 5 of them and you're like, you're an expert, right? But there's other things that are so important in the PPM. Look at those distribution waterfalls and reconcile it with the operating agreement. Look at the composition of the manager and its authority and other things, and then check that against the operating agreement. I've seen the biggest operators with discrepancies. Heck, I've had investors find discrepancies in my documents. I've since cleaned that kind of stuff up, but every now, look, this is human on human, interaction here, right? And so because we're all fallible, you just want to be scrupulous, because at the end of the day, if something's called to the carpet, you want to know it's buttoned up. As the investor, you want to have the confidence. And then conversely, as the manager, you want to have the confidence that you can undertake the property and know that you can do that as you've described, or as you've been authorized, without knowing that your investor is just going to call you up and sue you, or phone the SEC.
Right. That's awesome. And I know you mentioned a moment or two about Regulation 506B or Regulation D 506B offering. I don't remember if you defined what a substantive relationship looks like. Can you help us understand what that would be if you decided that you wanted to have non-accredited investors in your offering?
Yeah, so let's give it some context. I shot an email. One of my first emails this morning was responding to a client discussing this very same thing. She gave me a set of facts, and I told her, based on that, here's what you need to do. So the 506, okay, so harkening back to the development of the Securities Act of 1933, when they really understood that there was a restraint on trade by requiring that everything be registered and exempt, they really only wanted accredited investors to be able to contribute to these private offerings. And then they recognized, well, wait a second, that could be a restraint on trade, and you shouldn't be prejudiced in your investment life by virtue of not having these wild thresholds, right? That look, even in 2022, it's not common to have a $200,000 salary. Like, I don't care who you are, okay? And so it's a high threshold, but yet people do have liquidity. They may not have $1 million. And remember that the net worth determination on million is exclusive of the equity in your primary residence. Okay, so don't think, well, I've got a $1 million house and I owe 300K on it. They don't care about that. It's truly your other real estate holdings, cash and equivalents, and other investments to determine that net worth. Okay, but anyway, so they said, well, what if? And this is me pretending I'm in their mind. Of course, I wasn't there. I'm 35, and that's 1933. But in effect, they said, well, what if we allowed for non-accredited investors? And so the caveat was, okay, I think we can do that, but you have to know them, right? Because we don't want because if we let it just be anybody up to 35, then we could have 35 swindled investors, okay, on every offering, okay, and of course in the 506B there's no verification of any income, okay. We reserved that for 506C, and because you don't know the people conceivably in your 506C, of course you can know people in it. That's not the restriction, but that you can take people you don't know. You just have to verify their accreditation status. In the 506B, you have to have that pre-existing relationship and the reasonable belief that they're accredited to qualify. And it has to be a reasonable belief. That's not just like, oh, okay, I think they are. I mean, you have to be able to support that. And then the substantial relationship is really, and I have some colleagues out here and some operators that use the know, like, and trust. Do you know them? How well do you know them? Do you like them? Fortunately, the SEC isn't, that's not part of the SEC's. They're not like, do you like Tom? Like, it doesn't matter whether you like Tom. Do you know Tom? It's not whether you trust him. Obviously, you did if you placed your money with him, you trusted him enough. But they don't really ask, they don't quantify trust, but they do quantify no. And to some extent, they really qualify it, but then again, they don't, right? And the reason they don't is it's a facts and circumstances determination. They want it to be just nebulous enough for you to be able to go out there and transact things, but also they want to be able to hold that authority to determine whether something was appropriate or not. Okay. My personal philosophy, which has not been ratified by the SEC or anything, okay, I think you take always the prudent approach. And the prudent approach, the law is expressed that the first communication cannot be born out of the solicitation of the security. That's black letter law. So the first time I met George, I couldn't say, hey, George, do you like multifamily? Oh, I love it. Awesome, man. Well, I've got an offering. Here's my memorandum. Why don't you read this and you can subscribe today, if you read this and you're interested. You can't do that. Even if I saw you reading another PPM at a coffee shop and I'm certain, and I heard you on the phone, like, I got $1 million liquidity, I'm ready to put it on any multifamily. I'd invest it if a guy walked up to me right now and that ended up being you. You can't do that. You have to cultivate a relationship where there is that personal contact. And so my rule of thumb is literally at least 3 quality interactions. The first can be, it's not against the law to share in common multifamily. And a solicitation is really the actual issuance of the PPM subscription docs and receiving the funds for it. So you can talk about things in the abstract, that's why so many good operators who have public outreach do the educational programs, because they can pull them in and then start to establish that personal relationship where they can satisfy this requirement. So the short answer, George, is there is no express requirement. There's an express prohibition, which is the first touch. But I don't think I've sat in front of an SEC official on more than one occasion and talking about this very same thing and telling them that you talked to them twice is not going to be good for you. And they're going to write things down on the notepad that you can't see. Okay. And so I think you should do at least 3 interactions, okay, of a certain good quality where you feel like you know enough about that person that you can be like, you know what, I know George. Like, George, you and I have actually spoken to each other enough times that you could solicit me and I could solicit you. I feel comfortable and confident with that. Now, we met in person finally at the Jake and Gino event, which was fantastic, but that wasn't a requirement, particularly, post-COVID. Geez, everything is virtual. You know what I mean? So it's not about, have you ever shaken his hand? It's not that. It's just make sure you have enough of those mutual communication, both, not you met and then you're sending him emails and things like that, but true mutual communication, so that heaven forbid you ever get called to the carpet to explain your substantial contacts that that you feel confident and you can say, hey, here's my emails, here's my podcasts, or not podcasts, but here's my meetups and my interactions. We got coffee together, heck, we do a Bible study, we do these other things, and that overcomes it.
I love it. And let's get back to some other possibilities for how to sell securities. You can register the securities. Now, that's not usually done in a syndication. Do you want to tell us why?
So it's pretty cost prohibitive. All right. So a registration requirements, and there's several, because there's actually a number of forms. When you go into Edgar, which is the repository for the SEC, and you're filing documents, there's like a ton of forms. Okay. Now, most of those are not law I practice, and by the grace of God, I've got all that I can eat over here. So we're good. But there is a lot of registration, and there's billions of dollars spent in compliance for registered securities. Okay. The one that hits closest to home for our syndicators would be a Regulation A, which is a registered security. Okay. And under there, it's basically crowdfunding. You register it, meaning the SEC actually does pass on the merits, or at least qualifies your documents as sufficient for public dissemination. And then you can publicly advertise and take non-accredited investors. It's just an impractical tool for the most part for syndication type assets. Now, have you seen that Cadre app yet?
No, I have to look that up. Cadre, huh?
Yeah, CADRE. But check it out. It's like crowdfunding. You can like put in micro investments into multifamily stuff. That would be like a crowdfunding and is most likely registered. I didn't look to see. I haven't put in on that. I don't sponsor them. I'm just passing the name along as something that I saw and briefly looked into. There's probably listeners on here that know 10 times more about that stuff than I do. But my guess would be it's some sort of registered security where they're doing crowdfunding that would allow for anybody to put an investment into it, and then they take that corpus of funds and go acquire these multifamily complexes or whatever income producing businesses or real estate is part of their strategy. But it's a lot of money because you have to fill out a ton of forms and the paperwork. I mean, 95 pages for a PPM is nothing compared to what you have to compile for a registration and a registered security. So cost prohibitive and time prohibitive are the reasons why we just live in the exemptions.
For those who would like to have a Reg A fund, what do you think is the general cost range?
Well, so we don't do those. So my firm doesn't do those. I've talked and advised on them. It's generally to avoid, or hey, I think there's a better way that we can do this. My understanding is the street value of those things can be anywhere from $40,000 to $60,000.
Right. So cost prohibitive, a lot of paperwork. And then one thing you alluded to, but didn't really mention straight out, is the time, right? This is not something that fits into the time frame of a syndication. I understand it's maybe 6 to 9 months. This is huge.
That's right. And you're going to do more of it in a fund model anyway, right?
Yes.
You're not going to just raise this and go take down any old asset unless you're direct with the seller or something. He's waiting for you because you're going to give him such a high purchase price. On a 60 to 90 day PSA timeline, impossible.
Yes. And so what I want to really impress on people is there's various ways of doing things. Joint ventures are great. Syndication is great. It's not the only way to raise capital. You can do a Reg A fund. You can do crowdfunding. So definitely look into the options. But that Reg A, that's really advanced. You got to do, I would say, several syndications before you even consider that.
That's good. That's good general advice. That's good general advice.
And then how about the benefits of obtaining a securities license?
Well, people have asked me that. So if you go and get your Series 7, 63, and then there's like 65s and 66s, which are state specific, you can broker securities, and then you can actually link capital to the issuer, be paid compensation, and then leave, right? You can broker. You are a broker. In fact, you have to have your license held with a broker dealer, and then they have their own rules that govern you as what we call a registered representative. And then once you qualify for that, you're then under the auspices of, yes, SEC to a great extent, but even more so to FINRA, okay, which is the Financial Industry Regulatory Authority. Okay, it was normal like the NASD or something, and they changed it years ago. I worked at FINRA. Okay, and so that at that point you have your own disclosures and things, and that you have to do Form U4s, and you have to disclose certain OBAs, which are outside business activities, and other things. But you're subject to all the rules of FINRA that apply to you based on what you're doing as a registered representative. So it's not a license to go do whatever you want in the brokerage world. You're still subject to governmental oversight, and then you can conceivably have a FINRA rep or FINRA enforcement attorney and an SEC enforcement attorney in the same room, conceivably at the same time, asking you questions. So you would need, just to make sure and the reason that, and the way that would come about is if you tried to broker securities not using your license in some context, and so that implicated the SEC, and then FINRA would want to know because you didn't report it on your form, or as an OBA or something. And so you could really get yourself in a world of hurt. So while, yes, you could broker, you still have your own set of rules that make it a ton of, that can take some options off the table.
Yeah, certainly something I'm considering. I love the fact that you're mentioning the positive and the negative. A lot of people want to consider themselves capital raisers and go out and raise capital and be compensated for it without having an ongoing asset management role. And that's not a good idea. But if you do become a representative, like you said, that does open up a lot of opportunities. But then anything you do, let's say you have something that's small, like you want to do a small apartment, doesn't make sense to register those securities. And then you've got to actually go to the trouble of reporting it to your company, getting that OBA, making sure that you're properly approved, and then going forward.
That's exactly right. So it's not for everybody, and then every investment is not worth the time, heavy lifting, and other compliance things. So, while it could open up some opportunities, it can close some as well. So it's just another facts and determination facts and circumstance determination for you as the individual on whether that works for you or not.
All right, well, amazing. And I think we're going to have to call this because of time, not because there isn't more amazing stuff to talk about in terms of securities and some of the other models that are out there. But I want to thank you so much for coming on the show. And if people want to get in touch with you, Nick, how do we do that?
So I do prefer LinkedIn. Look, let's do that. We've got that way we can follow one another and engage each other's posts. So it's Nicholas G. Moore on LinkedIn, and then I've got my Robinson Franzman logo there as my kind of my backdrop, if you will, cover photo, even though I think that's a Facebook thing. So find me on LinkedIn. If you want to just shoot me an email, it's Nick, N-I-C-K, at rfllplaw.com. And you can drop me questions or just look to connect. And really those two methods are the best. And then from there we could schedule a call or a consultation, but I'm very responsive on LinkedIn. And of course, very responsive on my email. So look forward to some outreach. And man, I've really enjoyed this time, George. And this has got to be part one of who knows how many. But I appreciate you. You've been a gracious host with probably the most profound questions, at least from an academic perspective, that I've experienced with a host. And that's awesome, because I love that stuff. You can tell I nerd out on it. So kudos. Well,
thank you so much. And maybe we'll do a part 2 or 3. Thank you so much.
Very good. Take care.